Good afternoon, everyone. This is Mark Bloom. Welcome to our second webinar in the Financial Poise IP 201 series entitled Buying and Selling IP. We have a terrific session for you today, and we've brought together three experts in the field, and I will introduce them briefly. And please note that their bios are listed on slide 34 of the slide deck, and you can also find them on the Financial Poise website under faculty. Just a few housekeeping matters, just to mention our sponsor today, Financial Poise, as well as the National Law Review, which we will find on in the slides as well. And finally, just to remind everyone of a disclaimer that you likely hear if you participate in these sessions. The opinions that are in spoken words that we're going to be providing you today are our opinions. Please do not take them as legal advice, and that can be found in the slides as well. But to start off and get things moving, I just want to paint a brief picture for you. Let's say that I'm a new investor and I saw a video on YouTube and also on TikTok that said that buying and selling intellectual property will make me rich and make me rich quick. And I like the sound of that. And I'm thinking about starting a company that will buy and sell intellectual property. And I want to get a brief understanding of the basics before I make my decision as to how best to proceed. And I'm going to start with you, Fred. Fred Wilf is with the firm Wilf Legal Tech, LLC. And Fred, why would I want to buy and sell intellectual property?
Thank you, Mark. Intellectual property is a type of asset. It is specifically an intangible asset, so it's a little bit different from buying a house or buying an office or buying gold, buying a hard asset. So there are specific issues around that, but it has value. You can invest in it, you can build it, you can develop it, you can deploy it. And if it's misused or in certain cases copied, breached, misappropriated, infringed, you have a right to sue somebody and recover on that.
John O'Malley, who is a shareholder of Volpe & Koenig, based in Philadelphia. John, what types of intellectual property are there?
Thanks, Mark. There's four basic types of intellectual property, four basic types of asset, I guess, as Fred was saying. So you have trademarks. Trademarks protect brand identifiers. That could be a name, a logo, a slogan, trade dress. And a trademark has to identify the source of the goods or services that are being protected in commerce. Kind of famous examples of trademarks are the Nike name, the swoosh logo, the Coca-Cola bottle shape, things of that nature. Copyrights, they protect original works of authorship, and that can include literary works, music, art, photographs, software code. And the nice thing about, I guess, copyright is the copyright is there for you automatically upon the creation, but you do require registration in order to enforce copyright. Examples of copyright would be source code. I mentioned earlier, photographs on an e-commerce site, product manuals. The other right would be patents, and patents protect new and useful inventions and processes. You need to, in order to get a patent, you need to file an application with the United States Patent and Trademark Office. And there's three basic types of patent: utility patents, which are protect functional inventions, machines, processes, things of that nature. And then there's design patents, protect ornamental designs. And then you have plant patents that protect new plant varieties. And finally, you have trade secrets. And trade secrets protect confidential information that have some kind of economic value. But the key, always remember with trade secrets is the trade secret has to be kept secret or it doesn't really have any value. Again, there's no registration required for a trade secret, but you must keep it secret. And then for examples of that, you can see an algorithm, customer data, customer lists, a manufacturing process. So that's kind of a quick summary of the four types.
Thank you, John. I'm going to move on to Mitch. Mitch Weinstein is a partner with Levenfield Pearlstein in Chicago, the Windy City. Mitch, how can I buy and sell intellectual property?
Thank you, Mark. You buy and sell intellectual property like you buy and sell anything else. Okay. Um, through any sort of agreement. Sometimes intellectual property comes along with asset purchase agreements, or with the sale of a business. Or intellectual property can stand on its own 2 feet and be sold that way. You can sell or buy and sell a patent or a portfolio of patents. You can buy and sell trademarks, typically along with the business or at least the goodwill of the marks. Copyright's pretty much the same thing. You can, in any type of agreement, as long as the agreement itself doesn't violate any laws, and yeah, anything at all. I mean, any type of agreement. Typically, I would not suggest a handshake agreement. I'd make sure that those agreements are in writing, and I think we'll talk a little more in depth about what you should do in forming these agreements and what you should do in executing the agreements. But again, any sort of contract at all can be used to buy and sell intellectual property.
Excellent. Thank you, Mitch. Fred, because I am in this venture to make money, how can I ensure that I have a return on my investment? In other words, what can I do with the intellectual property after I acquire it? And just maybe give me some feedback in general.
Sure. And this picks up also on some of the things that Mitch was saying. Uh, if you buy some intellectual property in furtherance of a business, then you can use it like any other business asset to help move the business forward. If you buy the asset by itself, there are things you can do with it, such as license it out, such as sell it at a higher price, as you would with some other assets. You could certainly cross-license, which might increase the value of both your intellectual property, the asset that you own, and the asset that you have cross-licensed. And of course, if you see anybody is infringing the rights in your intellectual property, you can sue third parties. So it can be a sword, it can be a shield, it can be a trading chip, it can be any of those things.
John, what types of intellectual property can be bought or sold? Can all types of IP be bought or sold?
Yes, and this is kind of piggyback off of a little bit what Mitch was saying. Yeah, all types of IP can be bought or sold. There are a couple caveats though, or some things to watch out for when you're buying or selling IP. As Mitch mentioned, if you're selling a trademark or buying a trademark, it has to be sold with the goodwill associated with the business, or the assignment could be invalid, or the customer or the buyer is not going to get what they thought they were getting if they don't get the goodwill. And then with respect to anything that's federally registered, protected at the Copyright Office or the Trademark and Patent Office, you're generally going to want to record whatever assignment you have or receive, and then that needs to be in writing to have that. So that just those are kind of things to keep in mind as part of the sale process. And then another caveat, I guess, with trade secrets is they can certainly be transferred, but it's trickier with trade secrets because how do you know what you're buying unless you see the trade secret ahead of time? So this is where kind of having good legal counsel comes through, or you basically negotiate how you view the trade secret. Is it a black box or is it limited disclosure? So that can be a little bit more complicated, but it's certainly something that can be done. It just you have to kind of think it through a little bit.
Okay. Fred, I think I've made my decision. I think I want to go into this venture, even though deep down I know that I'm not going to become a millionaire overnight. But it does sound like fun. And now that I'm retired, I'll have something to do. Hopefully, the intellectual property rights that I acquire will last long enough for me to have a return on my investment. Is this so?
Well, it depends upon how long you want to use the asset, and that's going to change from one type to another. I mean, technically, if you want to, and of course, as lawyers like to make distinctions, we have to distinguish the asset itself from the legal way by which we protect it. So, for example, a piece of code can be protected by both patent and copyright, and as sold, it can be protected also by a trademark because that's the branding. Now, each of these areas of law have different laws. There's really different areas of law that are independent of each other, which is why we all have jobs for life because these things last a long time. A copyright, if it's created by an individual, can last as long as the original creator of that copyrighted work, who we call an author, plus 70 years. So if you write a book on your own and you start selling it and you kick off at some point, your estate still has rights for another 70 years. By contrast, a patent is a much shorter period of time, even though it might take a year or two for the patent to be processed through the Patent and Trademark Office, the patent side of the Patent and Trademark Office. Generally, patents will expire, utility patents at least will expire 20 years from the date that the application was initially filed, regardless of how long it took to get through the office. And then sometimes you can ask for an additional year or two in some circumstances. Design patents are a little bit shorter than that. Trademarks are interesting because it's entirely use-based. If you start branding a good or a service and sell that good or service, that trademark can last as long as you're selling, as long as you're using that mark. Some of the marks that we're using, such as Coca-Cola, have been protected as trademarks for over 100 years. And the trade secret also is pretty much use-based, as long as you can keep it secret, as long as it has value, as long as it's not determined and become part of the public, become part of the public knowledge.
I have a follow-up question for you, Fred. I've read that software can be copyrighted, but I find it hard to imagine that a software program is going to stay relevant for the length of time that the authors spent creating it, plus 70 years. Are there other types of protection, competitive advantage that I could look to that may not necessarily relate to something like copyrights?
Well, that's also why you look at, I mean, for something like software, certainly it may not be worth a whole lot in life plus 70, although we're seeing now, as people talk about old COBOL programs being replaced decades and decades after they were written, a lot of people are surprised that software's lasted as long as it has, in some cases at least. Certainly not in all cases. But this is also why you look at potentially layering types of intellectual property one on top of the other, depending upon what it is. If it is software, you can also layer in trade secret for anything that is kept secret. And to the extent that the software is being used as part of a larger device that otherwise qualifies for patent protection, you may be able to get a patent on it as well, even though a patent doesn't last as long as a copyright does.
And I would imagine that being the first to the marketplace would also be beneficial, correct?
Absolutely. Although, as somebody who works with a lot of startups, I have to say that first mover advantage is sometimes a little bit overrated. Some of the people who've made a ton of money were not first movers, including some of our current technology oligarchs were by no means first movers. And just recently, I was reminded of a factoid I had forgotten a long time ago, which is that Edison really did not invent the light bulb. It was invented by a gentleman named Swan, but it was Edison who deployed it in a way that he could make money. And he's the one who pretty much commercialized the light bulb. made it viable.
And I think was he the first to the patent office too?
No, actually, Swan got a
Oh,
patent
did he? Okay.
on the light bulb before Edison got the patents on any of his variations and improvements on the light bulb.
Ah, okay.
That's my understanding,
Yeah.
at least subject to correction.
John, I want to ask you a question that relates to money. What's the best way for me to determine the market value of my intellectual property that I may acquire? And spend a moment talking about, in particular, patents, because there seems to be a lot of patents out there. How do I value my patent to make sure that I get a good return?
Yeah, that's the $1 million question, so to speak. We get that question a lot. And then to come back to it kind of depends really. It depends on the nature of the IP and kind of your business model and the business context. So there's a couple like kind of basic approaches to valuation. There's kind of an income approach, and that's based on as future income or savings or licensing revenue. And a lot of times that would be from a patent. Um, and it's probably the most common approach used with patent valuation. Then you have a market approach, and that just basically is comparing the IP to similar assets bought, sold, or licensed. And that's generally most effective with trademarks and copyrights because there's more data out there about sales of those assets, and so it's easier to make those kind of comparables. And then you have a kind of a cost approach, and that's based just on the cost to create or to replace the IP, and that's probably most useful for income for comps where income or comps aren't really available, and so it's great for trade secrets basically. And then you look at other factors, kind of the strength of the patent in this case, or its enforceability, or the value to the business, or potential infringers, where if you could use the patent to monetize the patent, so you could kind of project income based on that. How much time is left is something to consider. If you have a patent that has 1 or 2 years left, certainly may have less value unless there's kind of known infringers, where you can go back a little bit. On the negative side, is there any kind of third party claims or encumbrances on the patents? So those are type of things that you would look at. And then, I mean, frankly, if you don't feel you have the internal expertise to kind of make these analyses, then generally people turn to outside experts, and they can be very useful. Obviously, the value of the IP has to kind of be commensurate with cost of the expert, but that's an approach a lot of people use.
Okay, thank you. Because I'm going to be in a business of marketing this intellectual property, let's say I focus on patents. As a part of my homework, I really want to understand the reasons why someone would want to buy what I'm selling. Mitch, what are some of the reasons why a business might seek to acquire my intellectual property?
Well, first and foremost is because your business wants to make money, right? That's really the bottom line here. But why would you want to acquire specific assets? You may want to expand your business into an area that you are not currently in. You may want to expand into core areas. And for example, I like to refer to creating a moat around a product or a service or a method that you have so that you could keep competitors at bay, or if not keep them at bay, at least make it that much more difficult or more expensive for them to try to come into your territory, so to speak. You may want to acquire fundamental patents where there may be a space with a lot of patents around. You may want to acquire some of the fundamental or basic patents in that area, once again to protect your turf. Um, you may want to be able to cover competitors' products with your patents so that you could enforce your patents. With trademarks, you may want to acquire trademarks so that, again, you could keep competitors source identification farther away from yours. You may want to acquire patents or any sort of IP really for licensing purposes, and cross-licensing purposes, so that you can really use it as a defense against an assertion of infringement against you, whether that's patents, trademarks, or copyrights. So there really is just a whole host of reasons to acquire IP. You may want to acquire IP just to increase the asset value of your company, because IP does have value. You know, if you look at Mark's, I don't know, John or Fred, one of you mentioned the Coca-Cola trademark just a little while ago. That has an awful lot of value to it. Um, Apple has an awful lot of value to it. Um, Tesla did, but now it has negative value. But you know, IP is an asset, just like anything else, just like a building, just like a home, just like a piece of land in an area where there's expansion. Um, IP will increase the asset value, typically will increase the asset value of a business.
Thank you. I'm going to just change gears a bit because I'm getting a little nervous about the complexities of buying and selling intellectual property. But I've done pretty well in my career and I have some money saved up. So I may look perhaps in the beginning to invest in others, maybe invest in some startups. And I was recently at an entrepreneurial showcase event that my nephew had invited me to, where the CEOs of these startups were talking about their companies and pitching for investment. And there was one presentation that really intrigued me. It was a company that had developed a new formula for what they termed a super soap that killed viruses on contact, including the virus that causes COVID-19. So you didn't have to wash your hands for 20 seconds. It would just do it immediately. And the company said, the company CEO said in his presentation that the formula for this super soap is a trade secret. But he made it sound like this is a fantastic business opportunity. But having just learned a little bit about trade secrets, I'm a little cautious. Uh, Fred, what are some of the things I should be concerned about if I have further discussions with this company as a possible investment?
Oh, if you're looking at a trade secret as being one of the primary assets of the company, that's, if you will, the fundamental asset, the secret sauce, if you will, going forward. Um, you have a couple questions because with trade secrets, the secret is valuable only so long as it has value for the company, which it does here clearly if you're using it, the formula for the soap, but also so long as it doesn't become part of the general public knowledge, uh, which can happen a couple of ways. One is that you want to make sure that the company doesn't reveal the secret by mistake. Two is you want to see that the company has a program that is preferably formalized within the company through a set of policies, statements, what have you, to keep it protected. There's been discussion and jokes about how the people who know the formula behind Coca-Cola never get onto the same aircraft in case it goes down. For the same reason, you want to make sure that only a small number of people have access to the secret behind the soap. And there's a formal process to keep that secret confidential, keep it secret, and use documents to do so. Now, you still have some concern there, especially in the startup universe, because a trade secret is subject to being revealed through what is called proper means. Proper means includes somebody buying, in this case, a bar of the soap, or if it comes in a bottle that has liquid soap, and putting it under a microscope and figuring out exactly what the chemical structure is. That's a proper means known as reverse engineering. We basically look as if we were engineering a thing, but we reverse it into its components and try to figure out what makes it tick, how does it work, how they build it. And that's a way by which the trade secret is essentially lost. And if that's the only way that you protect the soap, that's an issue. Now, hopefully, the company that you're looking at investing in has other reasons to have value besides the trade secret, but there are some limitations.
Mhm. Well, considering how many different manufacturers of soap there are, and I know that a number of them are very big players in the consumer products field, and having you describe how something could be reverse engineered, and it sounds like it would be kind of easily reverse engineered. It sounds like to me that this company would want to partner up with a much bigger player that could protect them from competitors. Uh, John, what do you think about that?
Um, you mean like in a kind of joint development agreement or
Well, how would I, as an investor, ensure that my investment is being cared for? So if I wanted to give some money to this company and I know that they're going to need to partner up, what could I do, and what should I tell them to do as an investor
okay. So
to help protect my investment?
sure. So if the, for example, if they the soap company, they use an outside manufacturer, specialty manufacturer to manufacture the soap. Um, they would want to make sure that they have agreements with the manufacturer, non-disclosure agreements, strict non-disclosure agreements, um, very tight non-disclosure agreements to make sure that the company, its employees, its vendors, any of its collaborators don't disclose a trade secret. If they're exchanging, um, if they have an agreement with the company, how to label materials, they should all be, labeled confidential. You shouldn't rely on just kind of verbal, anything that's trade secret should be labeled confidential. Um, make sure that the company's own employees and then the manufacturer's employees or the collaborating company's employees are trained on trade secret policies. And going back to what Fred said, limit access to absolutely who needs to know the secret sauce in terms of manufacturer and even kind of some kind of digital access control so that the formula is not sitting on a shared drive or something like that. That it's password protected, and that there's kind of a continuous monitoring for data loss or unauthorized access by employees, third parties. Because I think it's important if you're investing in a company and one of the main assets is the trade secret. Obviously, if there's a loss of rights because of it's no longer a secret, could be a tremendous drop in the value of that asset.
Mhm. Well, what you've described is making me a little nervous about my investment because it sounds like there's a lot of things that could go wrong if the company is not following the advice of perhaps learned counsel like the three of you. Uh, Mitch, just a question for you. I'm guessing that this formula would be potentially patentable. Uh, in this context, what do you think would be more valuable, keeping it as a trade secret with all of the challenges, or perhaps filing a patent?
Oh, that's a tough question. You've got to do some research before you make that decision. You know, Trade secrets can be very valuable. They can last a very long time. But as both John and Fred have covered, you really have to be diligent about maintaining the secrecy and taking reasonable efforts to protect um, whatever that trade secret is. Um, and that's probably IP, 205 or something, to really delve into what to do and how to protect the trade secret. Patents, on the other hand, as we've covered, will become public. So the term is going to be limited, although for something like soap, 20 years measured from the date of filing that commences on the date of issue may be sufficient. But what you really want to do is take a look at your soap, take a look at your formulation, and perhaps do a little research and a little searching to see what's out there. Because if you do decide to go the patent route, you want to make sure that what you have is in fact patentable, and that it's a valuable patent, and that it's not easily circumvented. That's one of the issues with patents, although frankly, I would say 70% of my work is in the patent space, but a good percentage of that work is helping competitors circumvent others' patents. And so you've really got to do your homework, do your research, and if you're going to go the patent route, make sure that what you have is protectable and that it has a reasonably broad scope. And if not, then trade secret protection may be the way to go.
Well, the thing that struck me about this company with the Super Soap is they seem to be operating on a shoestring. And I've heard that the patent process is pretty expensive. And I'll put this question out to the three of you. How should we best plan for the cost of the patenting process, and what would we think about as far as protection, as to where do we get our patents and what do we do with them once we have them? Anyone?
Well, patent protection is expensive, okay? And frankly, that's one of the first things that I tell people, particularly independent inventors, and more particularly and more specifically, folks that are garage inventors. I let them know that it's not an inexpensive process. You're going to look at doing some patentability searches, preparing your patent application, and prosecuting your application, and that's just in the U.S. It's not unusual to hit 10, 12, maybe $15,000 all the way through the process. And then, of course, there's the international process. Where do you want to file outside of the U.S.? And that could just, bring up big dollar signs, on the order of a couple of $100,000, just getting patent applications prepared and filed in many jurisdictions. And you have to think about the jurisdictions that you are going to go into. Where do your competitors manufacture? Where do you plan on manufacturing? Where are you going to sell? What may be ports of call for products that are being dropped off? And then there's, depending upon the industry you're in, if you're going to undertake freedom to operate or right to use analyses to make sure that you can do what you want to do without stepping on somebody else's toes. I know I rambled a bit. Fred
No,
and John,
it's.
I'll add a few points. Sure.
Well, it sounds like this company may want to use some of the money that I could potentially invest in them to use to help them obtain patents, if that's a route that's available. How do I make sure that I get my money back if I'm helping them cover expenses, but not necessarily getting a piece of the company in return? Uh, any business advice that you could offer? Any of you?
You can you can basically have an agreement with a company that uses any patent application as collateral for the loan. You're basically taking an interest in that patent. You have to record that not just as with any asset locally, but also in the Patent and Trademark Office. Essentially, you're treating that as collateral for the loan. You can otherwise, there's some other things you can do, but that's what I normally see in these issues.
Thank you. That's terrific advice. I think of what it makes me feel is that I may not have as much money to do this activity as I thought, so I'm probably going to have to to bring in some partners to help fund my venture. And I recently talked to a friend of mine. Her name is Anna, and Anna has a PhD in computer science, so she's very much into the new wave of computer technologies that are out there, including artificial intelligence. But like me, she's somewhat inexperienced when it comes to buying and selling intellectual property, particularly when it comes to something as new and dynamic as programs that are based on artificial intelligence. Uh, how are those types of technologies being protected these days? We've talked about patents and copyrights, trademarks, trade secrets. Have any of those types of intellectual properties been popular with these AI programs, or all of them? I'll start with John. John, what do you think?
Well, on the with a caveat, I'm not a patent attorney, so on the patent side of things, I wouldn't be able to speak on AI. I because I'm not familiar with that in terms of protection. But I guess on the copyright side of things, it's a developing field. But if the Copyright Office requires human authorship in order to be protected by copyright. So if it's generative AI and it's created by the AI essentially, then it's really not subject to copyright protection. There's some gray areas in terms of perhaps the human may have made some selections in terms of organizing outputs and things of that nature, which may or may not be copyrightable. But I would, if Anna's concerned about protecting AI output or things like that, she needs to be careful, and it's a constantly changing area. And I'll leave it to Fred or Mitch to talk about the patent side of AI.
Yeah, Mitch, we'll start with you about the patents. And I'm thinking more from the perspective of acquiring a patented technology versus worrying about what it actually does. Because right now I'm looking to populate my company with some patents that I could then market. So tell me a little bit about patents and AI.
Well, AI, I don't see any reason why AI technology itself couldn't be patented. Okay. I'm not, I don't operate a lot in this space, but if you look at the statutory requirements for a patent, I don't see any reason why AI technology in and of itself can't be patented. AI cannot be an inventor, because patents are issued to a person. Now, I think much along the lines of copyright, if there is human direction that's provided that rises to the level of patentability, then AI, let's say AI assistance with an invention, can be patented. But I know that's not really your question. I think your question is really more the heart of whether or not AI technology can be. I don't do a lot of work in that space. I do a lot of reading. I'm a patent nerd or an IP nerd, just like most of us IP attorneys. And I see Fred smiling there because he probably has the same affliction, and I'll let him go on about this. But I don't see any reason why statutorily AI technology in and of itself can't be patented. So I think Fred's chomping at the bit here.
Yeah,
So
go ahead, Fred.
No, I'm happy to reinforce what John and Mitch have already said. In working with startups, we do a fair amount of AI work. Got to say, we represent companies in AI, and I don't have the AI GP certification yet, but two of my colleagues do. We've been doing a fair amount in this, and we find ourselves in a very strange position right now, at least for the foreseeable future, which is, as John mentioned, as Mitch mentioned, you can have AI as the object of protection for both copyright and patent to the extent that they're otherwise meet the statute. They're a technology created by created or developed by a human. Um, the technology itself can be protected if created by a human. But if you use technology to create something such as code or anything else as an output, that output is not protected either by copyright law or by patent law. And that pretty much upends a lot of the business plans that investors have been using for decades for startup technology companies. And it has some deep implications for how you value a company, how you invest in the company, and so on, because to the extent that the crown jewels of the company are outputs of AI, those outputs are not protectable by patent or copyright. It may be protectable under trade secret. It may be protectable certainly on the branding side, but it's not the same thing. It's a different review.
Yeah. Well, it seems to me there's so many companies now that are marketing some form of AI, Chat GPT, Perplexity, Microsoft has Copilot. Uh, I can't imagine these companies doing things without making money. Uh, how are they monetizing this this new exciting technology? Because there seems to be a lot of people fighting for the space. But based upon what you just described, it's it's difficult for me to see, where the money is being made. Particularly that Anna is very interested in making money, just like I am. How do we do it, and what way do we look at it, Fred? So maybe you can have some insights if you deal with this area.
Sure, I'll start off. The most of the companies who are in the AI world right now, not surprisingly, making a lot of money in a couple ways. One is they certainly are taking in license fees. You can, as been proven time and time again, especially in whether you're talking about software that it might be open source and is otherwise not protected by for one reason or another, or even generic drugs that are not protected by patent, you can still make a lot of money by selling stuff and licensing stuff. So that's a good start. Certainly, you can get investment in companies for that purpose, as long as you understand that some of the crown jewels that you're using, some of the key assets of the company, are not protectable by copyright or by patent. And the value of the company is in the provision of services, essentially the stream of money coming in.
Just a follow-up question. It sounds like uh, some of the other intellectual properties that we have discussed may also have some potential interaction, kind of with the core technical aspects of these technologies. There's a lot of marketing that goes on, and particularly if you're in a very competitive market, sometimes the branding is the key uh, to uh, to get in front of folks. And if they need to pay money to subscribe, maybe they go one way or a different way. So how does that play into trademarks? And I'll open it up to anyone who wants to answer.
Yeah. Branding in and of itself is extremely important. Whether you're looking at products or services. I think, I don't know, Fred, was it you said that you don't necessarily want to be the first one in? Um, but you know, to me, the first player into a space typically has an advantage, and you know, the fundamentals of trademarks. You want to have a great mark. You want to have a mark that people recognize. You want to have a strong mark. Okay. You don't want to have a mark that is, certainly not descriptive of whatever goods or services you have, or suggestive. You want one that's easily recognized, though, that people will quickly associate with whatever it is you're doing, whatever goods or services you have. Um, you know, trademarks, for the basics, they identify the source of goods or services that are used in commerce. Everybody recognizes certain marks. Everybody recognizes Apple. Everybody recognizes Coca-Cola. Everybody recognizes Xerox, which almost lost its registration. Everybody recognizes Kleenex, right? Give me a Kleenex rather than give me a tissue. Um, you you want to be, I mean, in my view, you want to be the first one in with a great mark that people are going to recognize and say, "Oh, I know that," and they're going to go and they're going to buy that product or that service, or people are going to go to that particular store. Target, okay, it's a perfect example. Okay, um, I don't know who doesn't run to Target at least once every weekend for something, whatever it is. Uh, you know, whether it's something I need or something my wife says, honey, can you pick up so and so? To me, trademarks are extremely important. You can't put your finger on it, but yet the value of trademarks can just be, I mean, can just absolutely skyrocket. And on the other hand, the value of trademarks can also plummet very quickly. So you've got to really be careful of that. There's a lot to be said about trademarks and value and what you could do to build them and what you should make sure you do that you don't lose it as well.
Yeah, I would just kind of on that point about losing rights. If you are requiring a company that or a trademark, and that's the main value of what you're getting, rather than the products or software or whatever, you really should do some kind of true due diligence with the trademark. You want to verify ownership, chain of title. As Fred was mentioning, you want to see if there's any liens or any encumbrances on the trademarks. And then especially if the trademarks, generated from a startup or a small company, and they may have done it in-house, or there may be some vulnerabilities in the file history of the trademark that could affect the validity of the trademark. And so if it is an important, valuable trademark, due diligence would have an attorney look at the file history and see if there's any potential weaknesses in the trademark registration, even though on the face of it appears very strong. Maybe when they filed the application, they made mistakes that could have invalidated the trademark from the beginning. So the idea of due diligence, especially in trademarks, can be crucial if it's a valuable trademark.
Oh my goodness. We have covered so much today that I am very worried. I thought I knew a lot, but I've learned that I don't. So my business that I was hoping to get into, it sounds like I need a lot more advice. I need to do a lot more homework. Uh, we've talked about patents and trademarks and copyrights, trade secrets. There seems to be an intertwining of all of these intellectual properties in a business, and you have to think about all of them. You definitely need to have advisors, business advisors, legal advisors to get into this type of business. But one of the things that I wanted to just finish up with is, let's say that I get what I need and I start to make money, but then someone takes what I have. I don't know if steal is the right word. Infringe probably is a better word. Uh, what do I have to think about when it comes to protecting my investment from a legal perspective? And I would equate that to also an economic perspective. So if we can use the last few minutes we have uh, for our episode today and talk about that aspect of it. What do I need to do to protect myself and maintain the business that I hope to build. And I'll start with Mitch, and then Fred, and then lastly John.
Okay,
Mitch, go ahead.
I'll keep my comments short because I know time is short, but yet this is a very lengthy topic. What do you need to do? The first thing you need to do is to take your emotions out of it. Um, as I tell anybody that is looking to litigate, take your emotions out of it and make sure that the decisions that you make are economic decisions. Economic meaning that you can collect money now, looking at the longevity of your company or the particular asset, and that I mean it's just got to be a smart money move. That's first and foremost. What do you have to do? You've got to make sure that you own whatever the asset is and that you own the rights to enforce that asset, whether it's a patent, a trademark, or a copyright. Um, and it varies depending upon the type of IP, uh, the questions that you will ask yourself or of others. But the bottom line is make sure that you have the rights to the IP and the rights to enforce that IP. Um, and then you've got to decide, are you going to, pursue immediately? You're going to file a lawsuit, prepare and file a complaint. Are you going to serve it? Are you going to try to negotiate some sort of settlement before you get anywhere? Do you want to keep the alleged infringer out of the market, or are you willing to license and have them share the market with you? Perhaps in a given field of use, in given jurisdictions, or just regionally. Um, Again, I don't want to go on too long because I know we have only a little bit of time, but I think this is something where folks also want to hear both Fred and John's perspective beyond um, what I'm not punting here, mind you. I could go on for hours, like most lawyers could. But I just want to make sure that you hear everybody's perspective and what everybody feels is important. So I'll quit here.
Fred, how about you?
Okay, I think Mitch started off very well and hit all the key points. You have to make sure, certainly even before you go into litigation, the best thing you could have done is throughout this, make sure that all the I's are dotted, all the T's are crossed. For patents, making sure that once the patent issued, the maintenance payments are done. For copyrights, make sure there's a registration. Um, the old saying about there's two times when you want to plant an oak. One is 20 years ago. The second, and that's the best time to plant an oak is 20 years ago. The second best time to plant an oak is today. So you look around, do your due diligence, see what rights you currently have, see if you can improve any rights you need to improve, and then basically do due diligence on the litigation itself. How much would it cost? Where does it have to be brought? What are your goals? I'll second Mitch's point, especially on removing the emotion from it, because a lot of litigation is filed for the wrong reason, which is that people are upset. And once you take the emotion out of it, you're left with the financial issues. You're left with the specific legal issues. And what do you want to get out of this, really? And what do you expect to get out of this? And that's a good review, especially from the cost benefit analysis. Why would you want to spend $50,000 in litigation or more to spend what might be a $10,000 payday? Why would you spend $100,000 to chase $50,000? All good questions. You have to look very carefully, make sure you understand what you're getting into, knowing that, especially with litigation, it's hard to get out of it in a good way should you decide this isn't working.
Yeah.
John?
John, you have the last word today. Go ahead.
Okay. So I agree with everything Mitch and Fred said. I'd go like maybe a little non-traditional to kind of put a capper on things. Because a question we get a lot of times from clients is, why should I get a patent? Because I'll never be able to enforce the patent, and if someone tries to cancel it, I'm not going to be able to afford to defend the patent. And so I would just throw this out there for people to keep in mind, that the kind of non-traditional ways to maybe finance litigation. You can get, there is IP insurance. It can be a little complicated to get and it can be expensive, but it can be useful. I have seen it valuable for some clients. There are also, for high potential IP, there are litigation funders who will fund a patent litigation, and obviously they would take a large percentage of whatever is recovered, but that is an option if it fits in your strategy. And then finally, some law firms will take a case on a contingency or modified contingency case if it's if they're going after infringers. So there are some creative ways to try to finance litigation if you're a smaller company. All of these topics could be probably a separate CLE, but I just want to throw those out there.
Well, I want to thank Fred Wilf, John O'Malley, and Mitch Weinstein for their advice, their wonderful input and sharing of knowledge. And I would like to thank everyone for participating in today's webinar. And just as a heads up, we have the third in our series of webinars next month in May, where we're going to be talking about legal issues of inventors and innovators in the startup context. So with that, I will end this webinar and wish everyone a very good afternoon.
Thank you, Mark.
Thank you,
Thanks,
Mark.
John.
Thank you.
Fred.
Everybody.
Thank you
Been a
all.
pleasure. All righty.
Bye-bye.